make sure that the car is loaded in a way that will allow it to be hauled safely. That uneven weight distribution is a problem in all rail transportation. You want to try and make sure that you get the car loaded with as even a weight distribution as you can. So if you can eliminate those voids in the car, make sure that the car is fairly uniformly loaded, that produces a car that is easier to pull. So what we have so far is unloading, temporarily setting aside large chunks, and shredding. Then first the shredded material will be loaded in the car. Then the large chunks of large pieces of lumber or metal that have been temporarily set aside will be loaded in the car. And then it all goes. It all goes to a landfill somewhere. And I think preliminary conversations have been had with a landfill in Ohio that has indicated they're willing to take this kind of material. And I think the bottom line is what comes in will go out. There's no recycling going on. There's no sale of lumber or metals. And again, as Mr. Motes indicated, the only activity, the only exception to that is that if there's some hazmat comes in for example, in a form that's identifiable, or if a refrigerator happens to be in the load, and there are rules about sending refrigerators to landfills, and you can't do that without some certification. So things that like that will be segregated and either sent back to the shipper or disposed of, or the shipper will be called to come pick them up. But again, what comes in will go out, and not in any revenue generating way to New England Transrail. With respect to MSW, there are a variety of things that could happen to MSW in the sense of how the MSW gets loaded on the cars. It could be just picked up and dumped, raw MSW just dumped in the car. It could be compacted in a way that forms a sort of a bale that allows it to be loaded more efficiently, meaning fill up more empty space. Or it could be baled and then wrapped in some kind of a plastic wrap to contain it better and make sure that it doesn't blow away, and those kinds of activities. But what's definitely, I should point out that baling MSW allows it to be transported in a wider variety of rail cars. So there is, in addition to the purpose of making the filling of the rail car more efficient, it enables the MSW to be transported in different kinds of rail cars. So what's not going to happen with respect to MSW is the kind of thing that happens at a solid waste processing facility, where people pick through the solid waste and pick out things that might be valuable for recycling purposes or otherwise. That's not part of the process. And it can't be, as we point out, because New England Transrail is not going to have title to anything ever that comes in this facility. It's all going to be shipped by somebody else, received by somebody else, and New England Transrail's function is to get it from the trucks to the train and get it into the interstate rail network. And that, I think, is the best description I can give you, sir.
Thank you. That's helpful. How many rail cars would you anticipate, or your client anticipate, coming in one unit at one time? These would look something like truck chassis, or be similar in size to a intermodal truck chassis type size car. And how many would you're talking 20, 30, 40 cars at a time, 15?
Well, Mr. Klempner and Mr. Jones are sitting here, and I can see they're eager to say something. With your permission, Mr. Chairman, I think that that's a subject that they could just answer directly your question without any other comment, if that's all right.
I'd like, if with the permission of my colleagues, to invite anyone you feel is instrumental in shedding light on this case to come forward and please identify themselves.
Let me give up my chair for 30 seconds.
We have extra chairs too. We can slide around. I think there are wheels underneath them.
My name is Ron Klempner. I'm a principal of New England Transrail. In answer to your question, as to C&D MSW, we'd expect between 10 to 15 cars coming in on a daily basis. Overall, we'd expect around 30 to 40 cars coming in, including the C&D and MSW cars.
Is your business in seeking to attract those 10 to 15 cars of, did I hear you say that would be a combined total per day of both MSW and C&D?
Correct.
In pursuing that objective, are you somehow involved with generating that traffic? In other words, if you fold up after today's hearing for some reason, decide not to pursue this, what's going to happen to those 10 to 15 cars? Do they disappear, or are you somehow creating that demand with this business plan, or is that demand already in existence and going to go somewhere in the economy and over the transportation network somehow? It's just a question of how.
Yes, that material will go by truck and then come into the Massachusetts by truck. In terms of the C&D and MSW, it'll continue to go out by truck.
And so fair to say 10 to 15 cars would be 10 to 15 more trucks?
No, it would be
each day, or
around 5 times that many trucks.
So you're talking about 10 to 15 trains full of multiple cars?
10 to 15 cars, and about 5 trucks to a car.
Okay, because as a result,
5 truckloads would go into a car, or would be equivalent of 1 car.
The cars are either the rail cars.
Let me state it another way. 1 car would hold the equivalent of what 5 trucks would hold.
And that is because why?
A car, you can put 100 tons approximately in a car, and you can put maybe 20 tons in a truck.
Okay. Is that also the result of any type of handling or processing that you would do to the material, the grinding, the cutting? I don't know if I heard you say cutting, Mr. Macelli, but the dumping, the shredding, the compacting, the baling, the wrapping. Does that actually help you get more material onto fewer rail cars?
Yes, it does.
And so again, we're looking at roughly 5 times that, so somewhere between 50 and 75 truck cars. Trucks would be actually taken off the highways. Obviously, they've got to get to you, so they're on the highways for some level of time, but presumably they're not going to meander through on their way to Ohio, going through dozens and dozens and dozens of communities.
Correct.
Okay. Let me pause and just give, while we have Mr. Klempner before us, let me pause and ask if the Vice Chairman, and then I'll ask Mr. Mulvey if you want to have any questions that he might be uniquely positioned to answer.
Who is your customer?
The shipper of which material are you referring to? The C&D?
You have a developer who wants to develop something, and so he has to tear something down to be able to develop something, and so he creates all this waste. And so he's paying a company to demolish a building. He's paying somebody to take it away. Are you the person who takes it away, or somebody else takes it away and brings it to you?
No, a demolition company or a container rental company would be the person that takes that away, and they would be our shipper.
They would be your shipper.
They would be our shipper.
The developer is not your shipper.
Correct.
Okay. So the developer's paying you a fee. They're going to bring it to you. They're going to pay you a fee to make it disappear.
The developer pays the demolition company, right, or the container company,
right,
and then they pay us a fee to transport the material to the destination that they select.
Okay, which includes, I presume, some type of payment to a Class 1 carrier to take it off of your property, to pull the train, to pull the cars that you position for them off your property and take it to its final destination.
Correct.
So your business plan is basically to take a fee from the debris transportation company, and then pass that fee on, or pass part of that revenue on to the Class 1 carrier.
Correct.
Take into consideration the cost of all the stuff that you have to do to it to get it ready to go.
Correct.
And part of that fee also includes the payment to the Class 1 carrier to get it from point A to point B.
Correct.
Okay. Just curious about how that works. Connect the dots, as it were. Yeah.
Any additional questions, Vice Chairman Butler?
At the moment, no.
Commissioner Moley?
I have a couple of questions. Could you please detail your experience in the solid waste management area as opposed to your experience with railroading?
In the solid waste management area,
Solid waste processing or area, so.
I became involved in a medical waste incinerator for a couple of years. It was purchased by BFI. I worked for BFI for 2 years, and in working for BFI, I was basically involved in arranging rail transportation for them.
Okay.
And that was up until 1997. Since then, I've done some consulting, a variety of consulting jobs involving both waste and non-waste materials on rail.
As a former Massachusetts resident, I probably should know the answer to this question, but I'll ask it anyway, and that is, does Massachusetts have a recycling law right now? Do people separate their household materials before they go to the before they get picked up by collectors?
I'm not a Massachusetts resident, so I could not answer that. Maybe.
I guess my question is, would you be handling mixed MSW, or would it be pre-separated and pre-segregated when it comes to your facility, or do you know that?
We don't know that. We don't have our MSW customers yet.
Mr. Chairman, may I ask one more question?
I will say, I think I have a hunch that there are witnesses later who can answer those questions.
A statement was made earlier, I think, by Mr. Van Tine, although I think he may have prefaced his answer by saying he may not be the best person to answer that question. Maybe there's someone else here from the company that is the best person to answer that question. Or maybe you didn't say that, Mr. Van Tine. I'm not quite sure. But anyway, I was curious. One of the questions that was asked in the documents preparing for this hearing, asked by us and to ask you to prepare for this hearing, was, and it was answered, I think, somewhat unequivocally by you, Mr. Van Tine, and that is that there, as far as you know, there are no requirements of the receiving landfill facility that requires you to do some of the things you do to this material before you put it in the rail car. Is that accurate? I mean, it sounded like a very unequivocal statement to me that is indeed the case, and I think we need to get on the record whether you do some of the things you do to this debris and waste, et cetera. You do that because if you don't do that, the landfill just won't take it, and they're going to send it back. Is that, can someone answer that question? I know we do have witnesses later that may be able to answer that question, but since it was a statement that was made somewhat unequivocally by your witness, I'd like to get some clarification on that. And if you just don't know, you just don't know. But I'm just curious.
Nothing we do to the material is done as a result of requirement to the landfill, other than make sure that materials that aren't acceptable to the landfill, such as hazardous waste that we may find, does not go into the rail car and to go to them.
And nothing is a part of the processing, if you will, of the material is something that none of the processing that you do is a result of some requirement of the landfill itself.
No.
Okay.
And Mr. Vice Chairman, if I could just add, I think that what you're referring to is what my remarks in connection with, for instance, the refrigerator example. There are some things that landfills, by law, they just can't take unless there's a certification that it's the fluorocarbons have been removed and that kind of thing. And as the operator of the facility, the receiver of the materials, if something like that comes in that we know by law can't be shipped to a landfill, then it comes out. But there's no unique requirement of the landfill that will be facilitated at this facility.
Thank you.
I have one more question also.
Mr. Moley?
Solid waste processing, this was solid waste processing. One of the value-added aspects of it is the recovery of recyclables, especially metal, aluminum cans, and the like. And you're claiming that you're not going to do any of that separation at the site. My question to you is, why wouldn't you, since that would be a source of revenue for you to do that separation?
We don't have the space for that, and it's just not part of our business model.
I have a question or two for Mr. Van Tine now. I think we can temporarily at least dismiss the other two witnesses. Thank you. Mr. Van Tyne, I think these questions are very important to me, so I just call your attention to them. I know it's been a long morning. Thank you for your patience. This is important, though. If, and it's a big if, but if this board were to decide we had jurisdiction in this matter as a result of today's hearing and the other evidence in the record, and assuming, though, we have some pretty strong concerns about making sure public safety, health, and the environment are protected, as you would, I assume, expect us to have, how can we assure that there is accountability, that there is a mechanism put in place that ensures that your client's operation, because unfortunately, Kirk Van Tyne is not going to be the forklift operator. I don't believe that Baker and Botts will excuse you to do that. So you're not going to be out there 2 years from now, 3 years from now. It's going to be the good people we just heard from, and probably won't even be them. It'll be their employees, and we like to think that everyone will have the best public interests at heart at all times. But let's face it, these facilities are not what you see in Better Homes and Gardens. In fact, frankly, no major rail intermodal type facility I've been to does look like that. But what can we do? And let me give you an example. If we were to enter into a series of strong conditions with your client, a conditional approval of this type of operation, that would come later, of course. We would do a full environmental impact statement. So assuming your client cleared our NEPA process, which would be full, of course, of public comments and response actions to public and state and local concerns, assuming the EPA ever completes, assuming they ever begin, which they haven't done yet, the RIFS, and we decide we want to enter into a strong set of conditions with that would be self-executing and almost in a way that would be very clear to the parties what type of inspections would be done, and ultimately that the board would have the very swift opportunity and requirement, really, to come in at the request of the state, for example, and actually issue an injunction or shut your client's business down temporarily to get to the bottom of a good faith environmental safety or health concern that was raised based on a state inspection, for example. Would your client be willing to enter into that kind of a binding arrangement, or do you have other suggestions for us?
First, let me say that it would probably be a lot more fun to be the forklift operator than doing what I'm doing now. But I think there are a number of things that I'd like to say in response to that question. First, I think we don't want to delay this proceeding, but on the other hand, we have read everything that's happened in this industry for the last few years. We understand the good, the bad, and the ugly, and we want to be the good. And we have designed this facility to operate in a way that will not cause problems for the local community, and we're not afraid to talk to people about what exactly will happen and how it will be carried out. And we have always said that we're willing to enter into an agreement that would permit Massachusetts authorities to inspect the facility and permit them to enforce their state laws as long as they don't unreasonably burden rail transportation, with the understanding that what unreasonably burdens rail transportation is for this board to decide ultimately, or in appropriate cases it may be that the court could decide that. But we, in concept, believe that it is possible to arrive at that kind of an agreement and understanding, and I think that what we would suggest, and I think you're sort of stealing my closing here, Mr. Chairman, but what we would suggest is that to work out the details of how such an agreement might be entered into or phrased or framed, we would be happy to be the test case and the model case. And I think that just a suggestion, what you might want to do is have your general counsel and the general counsel's office and your professional staff sit down with us and with the Massachusetts authorities and perhaps with other people who have some expertise and some knowledge in this area, and work through some of the issues in a less formal setting, but have some give and take about what should be included, what shouldn't be, and again, without wanting to prolong or delay this proceeding any more than it has been, set up some kind of a procedure like that where we could, without any obligation on your part that it would be binding in all further proceedings, but just a sort of a guidance and model agreement that might satisfy everybody's concerns. And we'd be happy to participate in that. And if the board decides that it's best for private parties in the states to work that out by themselves, we'd be happy to do that too. And I think that, finally, even if I'm not driving the forklift, Mr. Klempner and Mr. Jones have been very well educated about the law in this area so far, and they're going to have good legal advice from us or from somebody, and we have a sense of who or what kinds of activities unreasonably burden rail transportation, have been held to unreasonably burden rail transportation in the past, and I think that the operation of the facility will be governed and constrained by the practical consideration that if you know the law, you know what will be upheld and what won't be upheld, likely. And so you're not going to argue about the little things. You're going to, if there are rats running around, you don't want rats running around. And you're going to clean up the little things because you know that if you were to challenge those little things, you ultimately would lose. And it's the things that would shut down the operation that you're going to worry about. And I think those are the general answers to your questions, Mr. Chairman.
Thank you. You have certainly responded. I do want to try to pin you down, if I could, a little bit on what I view as a very important, not just one board member here, I'm not speaking for my colleagues, they will speak for themselves very ably, but I'm envisioning the possibility of having those kind of discussions leading up to ultimate decisions which could go against your client completely or partially or not at all. So again, just a reminder that today is a very early step in the total timeline of the life of this project, if we were to even assert jurisdiction. But if we were to do so, one of the things I would want to explore very firmly and very clearly is how Massachusetts state authorities can inspect your facility as our delegates. We don't have a large staff. We don't have badges and guns, and we don't have expertise in the ground operations of transload facilities. So we would need to delegate that to somebody, because we could subcontract out to some expert or presumably work with the state, who presumably has some of that expertise. They're going to want to know, I'm quite confident, I'll ask them, of course, in a few minutes, what happens when they find a violation. What do they do, and how long will it take for corrective action to be taken? And my answer to them would be, I believe, you let the STB know, and within 72 hours, we will shut that place down until we find out what's going on. And so that would be based on a verified statement, not just some random rumor in the neighborhood, but some verified statement that an officer of the Commonwealth saw something very specific and it violated the following provisions. And we would need to see the operation, in my personal views, speaking as one commissioner, shut down temporarily until we get to the bottom of it and then figure out what other law enforcement or other officials need to be brought in. Is that the kind of arrangement that your client is willing to enter into? Because I think that's going to be a key and very understandable concern if you're representing the people of Massachusetts, which we'll hear from these representatives soon. Where's the recourse? How does this work? If there is a problem, we can't just go on trust and hope. And so I'll pause there and let you respond to that.
I think conceptually, Mr. Chairman, that's absolutely what we are interested in talking about. I think that our concept has always been the state would be allowed to inspect. We would discuss the violation with them. We would try and take corrective action. If there is a major disagreement, that disagreement would be resolved by the STB, would be taken to the STB and resolved by the STB. Now, when you say shut down within 72 hours, I would hope that there's some spectrum of violations that wouldn't necessarily justify a shutdown, but in an appropriate case, conceptually, that would be something that we would be happy to talk about. One of your questions started with the issue of how practically such a system could be set up. And one of the questions that you asked us to answer in the plating on Monday seemed to be going in that direction, a request to list the federal statutes which included some, which might be applicable and which included some delegation to the states for enforcement purposes. And I think that what we listed was mostly environmental statutes, but the thought that occurred to me, which I'm sure will be familiar to all of the board members, is that there are a number of programs that are run by the U.S. Department of Transportation where there's federal authority and federal jurisdiction, for instance, in the hazmat area or the pipeline safety area, which is exclusive jurisdiction. But for instance, just taking pipeline safety as an example, the Federal Office of Pipeline Safety has developed regulations and criteria for delegating inspection authority and some enforcement authority to state officials. And if states do the required things to qualify for that delegation, they are delegated the authority to send out their inspectors. And in concept, I don't see any reason why you couldn't set up a workable program that embodies the same structure.
Thank you. My final question will be on the question of whether we've heard in the record some different characterizations of the activities. Well, first I'll say, going back to the last question, bear with me. In the record and in your testimony, I've heard you talk about your client's concerns about not yielding unfettered discretion to state and local authorities in the areas of site assignment, pre-clearance, and noise. And let's put noise aside. That's a pretty well trodden area. There are federal noise regulations, a lot of case laws and recent regs in that area. Site assignment, is that if local or state folks want to tell you where you should put your warehouse, where you should position something, basically run your, in your view, kind of make business operational decisions for you?
Yes. Before I answer the question, I think that the concepts of site assignment and pre-clearance requirements have been discussed in a number of board decisions and court decisions. And I believe, again, I'm not truly an expert in this area, but according to the cases I've read, they've been categorically preempted. The reason for that is that not so much that the local authorities will try and shape the project to make it comply with health and safety or environmental requirements, but because those kinds of site assignment and pre-clearance requirements can be used to block a project entirely for any reason or no reason, basically. There are a few criteria that apply in some cases, and they may not be fairly applied in other cases. So I think that I think that is where the legal line is drawn, and I think that's the line that we would say should be drawn in this case.
And I guess similar thoughts would relate to pre-clearance. That
Yes, sir.
It's a pretty general phrase that could be used to really string.
Yes, sir. I'm sorry to interrupt you.
String out the project. Really.
Same answer. That's the reason that's one of the reasons the preemption requirement exists, so that the states and local authorities will not be able to block a project that is important to the rail transportation network.
So to sum up, with the exception of site assignment, pre-clearance, and noise, which are areas that have a pretty extensive set of precedent and experience before this board. Everything else is on the table, so to speak. In other words, if we were to grant jurisdiction today or after today, everything else regarding the activities at your operation, your proposed operation, are basically negotiable between the board and your client with the appropriate involvement periodically of other state and local agencies that have expertise in certain areas.
Yes, Mr. Chairman, I would suggest that the Massachusetts authorities are the ones who really need to be at the table. We don't pretend to be experts on Massachusetts law, and we've tried to identify those Massachusetts statutes and regulations that we think would be applicable. And again, as I said earlier, in concept, we don't disagree that a certain number of those would be applicable. And I think the three exceptions that you mentioned are the only ones that we've identified. We would, of course, want to make sure that we have a meeting of the minds, with the Massachusetts authorities about whether there is anything else out there that we haven't identified and we need to talk about.
And of course, when I describe that hypothetical, it's all within the bounds that I believe this board would always stay within a realm of reasonableness, where we would not be asking any railroad to proffer some hospital construction project or a college scholarship fund or something because we have other hopes and desires that have nothing to do with your project. So within a realm of reasonableness that relates to your project and its impacts, everything else will be on the table, if I hear you correctly.
We support reasonableness.
That concludes my questioning of Mr. Van Tine. I want to defer to Vice Chairman. Seeing a nod. Mr. Mulvey, any final words?
I'm sorry, yes. In the Massachusetts party's statement of position, they argue that if the board were to authorize the New England Transrail's proposal, we should only do so to the extent of New England Transrail's rail-related activities and not to its solid waste processing activities. How practical would that be, given the proposed rerouting of the tracks through the sprung structures in which the waste and debris would be handled? Would it be practical to separate the two, or where we would regulate the rail transportation but not regulate the processing facility itself?
The assumption of your question is that there is a processing facility in the sense of a solid waste processing.
Let me add to it a little bit, because basically this is all about siting. I mean, is this anything to do with how the facility is operated, or is it mostly about siting the facility? And that what the issue is whether you can actually put this facility where you want to put it. And if we presume that we give you the license to build the railroad, and then I presume that you can build any kind of facility you want on that property, and then the state of Massachusetts would regulate how that property is operated with regard to handling municipal solid waste and construction and demolition waste. Is that a feasible outcome?
I'm not sure. It sounds to me as though you're suggesting that the commodities to be transloaded that are not waste or waste related could be transloaded at the site, but C&D or MSW would have to be handled somewhere else. And I don't think that's possible.
It could still be handled there, but they would have to be handled under existing Massachusetts. The Massachusetts DEP would have the right to impose the regulations and conditions as to how they are processed, consistent with the way those are in other facilities similar to yours around the state. You wouldn't have the exemption.
I think that's part of what I've been discussing with the chairman. That I think in concept, the idea that we're proposing is that the Massachusetts authorities would have the right to inspect and apply Massachusetts law to everything that goes on at the site. The test that the board has laid out is whether the state law unreasonably burdens rail transportation. And so we would propose an agreement with the state about what state laws would be applied at the site, and once we reach that understanding, I think there's no reason why the concept that I think you're suggesting couldn't happen. I think I would say again, though, that nothing that happens at this site is solid waste processing, we would say, and we believe truly that it is directly connected to the process of rail transportation in that it all relates to the loading of the materials into rail cars.
Let's put the difference called solid waste handling. So we don't have a processing versus loading, but all solid waste handling. But under preemption, we would preempt Massachusetts law as regard to them regulating your operation there. You're suggesting that we can somehow delegate that responsibility to the state, and that the state would have enforcement authority to enforce its rules and regulations, even though theoretically we preempt state law with regard to a railroad operation?
I think the preemption, this goes to the question of the regulatory gap again, and I think that you're implying that there is either complete preemption or no preemption and maybe something in the middle. And I think that legally there is not complete preemption. There is preemption of those activities that unreasonably burden rail transportation. And so it's for the board to decide what activity, what local regulations, state or local regulations, unreasonably burden rail transportation. And so I would suggest that the question of whether a particular local or state regulation is preempted doesn't arise until the state tries to apply that particular regulation. And what we're suggesting is that we work out in advance what regulations would be applicable to the statute. So there's no misunderstanding about that point, and so we don't get into the situation where the facility is constructed and in operation and then the state pops up with a regulation that we didn't think of, which the board ultimately holds is not preempted and results in shutting us down.
Well, I'm not a lawyer, but you're suggesting that you and the state of Massachusetts can decide which laws apply to you in an agreement. But is that true, that you can confer through agreement what laws would apply to you?
I think that we probably can reach an agreement. I think that to make it binding, valid, the Surface Transportation Board should see that agreement, understand what's in it, and understand what the process is going to be. And the board does not have to formally approve such an agreement or be a signatory to it, but it, I would conceptually think that it would be more like an item of evidence in this proceeding. And the enforcement of the agreement could be through a variety of mechanisms. I'd say we can talk about that and work that out.
There is concern that this is not an isolated case. There are many of these potential around the country. As I know very well, landfills are filling up all over, and there's a lot more transloading and shipping, processing, what have you, of visible solid waste and C&D waste. And there is some concern that we would wind up being flooded with a lot of, if these things were to go through, eventually there was some concern about what was agreed to and what the legitimate role of the state is in regulating these things, then these things will be coming back to the board over and over and over again. And there are some limitations as to what our abilities are to do so and to handle these, and what our expertise is. We have expertise in handling environmental issues regarding the transportation. When people build a new railroad or abandon a railroad, we have an environmental review process to make sure that water quality, et cetera, the historic markers and all that are preserved. But we generally don't deal with the environmental issues associated with the operation of railroad facilities. As I said, it's sort of a regulatory gap. So we are concerned about whether or not this is opening up some sort of Pandora's box for us as well. So that's all I have.
I'll just follow up just to clear up any potential confusion, because Mr. Van Tine, you did mention earlier that you're not a day-to-day railroad regulation and law practitioner. Mr. Moses, you may be able to offer something on this. You may know, though, Mr. Van Tine, I'll say it for the record, that on almost a daily basis here at this board, certainly on a weekly basis, We issue what I would call routine decisions regarding things like abandonments. And in most of those abandonments, those routine decisions, we include conditions. And more often than not, those conditions, and these are in the most routine matters, but abandonments, of course, are spelled out as one of the items that are protected under preemption and statute. We tell the railroad applicants seeking to abandon to make sure they get state approval to remove a geodetic marker, to make sure if they're disturbing any land, there are no burial remains that might be historically significant. So we're very accustomed to very detailed, in the most non-controversial, low-impact environmental type transactions, deferring with and working with states and making sure the right thing happens. And I would just say, as one commissioner, since we're talking about a higher impact potentially project on a Superfund site in a community that's had to go through an awful lot in its history, I personally would obviously look at this, as you say, a test case to have a very creative, very specific, very lengthy, very detailed, and very reassuring to the Commonwealth and its citizens set of conditions that would trigger prompt and immediate action that would protect the public interest. Doesn't mean that you necessarily today would subscribe to be underneath every single law or regulation of the Commonwealth, because what I'm hypothesizing here is that federal preemption may apply, but nevertheless, this board would then have a public interest responsibility to make sure the right thing happened, just as we do in the most routine cases. With that said, I'll let you respond. And Mr. Motes, if anything I've said sounds familiar to you in your years of railroad practice.
Do you want to go first? I would just say that in concept, everything you just said is fine with us. We would be happy to. We anticipate that there will be mitigation conditions, for instance, in connection with the environmental review. And we understand that, and we understand the concept of conditions, and we would like to be able to discuss the conditions that are necessary before they're imposed with the board staff and with Massachusetts authorities, and again, make sure that the that the conditions are reasonable and directed towards the health and safety purposes that we all agree are important. And we're hopeful. You can't guarantee everything in life, but I think that in this project, we're trying to do the right thing. We're trying to be, again, on the good side of have a quality operation that does not create problems for the community, does not exacerbate environmental problems at the site. And so, conceptually, the idea of conditions is not something that we would be afraid of. We would be happy to talk about conditions in the order, and we understand the concept very well.
Mr. Motes, do you have anything to add?
Well, I do, and I don't want to make things more difficult for you, but I can't entirely agree with your proposition. Your staff does have the expertise you describe, and as you say, Mr. Chairman, on a routine basis, those kinds of issues are dealt with, for example, in abandonments. Statute gives you, obviously, express jurisdiction over railroad abandonments, and it's in connection with an abandonment application that you append those conditions. We're talking about exemptions. Exemption, in this particular case, the class exemption, I guess, to become a rail carrier, to be deemed to be a rail carrier. I think there's much more question about your legal authority to condition an exemption. I do think you've touched on something, though, that can be is very critical here, and that is the very unique nature of this particular proposal. I'm not at all sure, Commissioner Mulvey, that there are going to be dozens of these proposals coming from all over the country. I would hope there aren't for your sake. But if there are, I know I sound like a broken record here, but I think it's a record I'm playing for the whole rail industry in a sense. We feel that most of the problems that have been identified in recent years in this area have come from the exemption procedure and perhaps the board not having as much information from entities that are invoking the exemption procedure as to what the nature of their actual operations are going to be, who their principals are, what their sources of financing are, what are they really planning to do. I think there's a lot you can do in that area. And you already have done that to some degree. You've slowed that procedure down. I think that's a great first step, and there'll be more public participation so that communities like the one, as you say, Mr. Chairman, here that has been through a lot. Just as a personal point, I graduated from high school and an adjoining town to this town, and I know what this site is. I remember when I was a kid. And it has a rich history. I think we all know that. Hopefully, a lot of that rich history and the fact that this is a Superfund site and all the complexities that brings is something that you might well invoke to try to do something here that would go beyond what I think you normally should or could do in a regular exemption proceeding. You made one other comment a minute ago, Mr. Mulvey, if I could just, or at least in part of your question, maybe you had a comment that I might be able to help on, the idea of can they enter into an agreement with Massachusetts to agree to be bound by certain laws. I think they can, and well, unfortunately, this has not got a real happy history either. My client, the Susquehanna, has entered into a couple of years ago an agreement with the New Jersey Meadowlands Commission, which is the other entity in the Jackson litigation. It has jurisdiction over the New Jersey Meadowlands, which are the, I think you know where that area is. You can see it in some of those photographs if you ever watch the opening scenes of The Sopranos. That's the New Jersey Meadowlands. But there is a commission that has jurisdiction over that, and my client entered into a contract, a private agreement to settle some litigation with the New Jersey Meadowlands Commission, and that agreement commits the railroad to do certain things in connection with, for example, construction within the Meadowlands area. Now, the Meadowlands Commission and the railroad have disagreements about what's required, and dare I say it, they're in state court in New Jersey litigating over that agreement. But it is an agreement, and there are, I mean, these are complex issues, and there are ways to address them, and that might be one. You know, I could imagine an agreement that would be between the Commonwealth and NET that might not require your being intimately involved to deal with issues that arise under it. They could put in provisions to have Massachusetts state courts or even conceivably an arbitrator deal with it.
Ms. Rhodes, I know I'm mindful of time. The rest of the witnesses have been very patient. I appreciate that. Let me just make sure I understand your response. You did recognize, if I heard you correctly, that conditions are a routine part of the board's business, conditional approvals of various applications. In this, not in your client's fact pattern, but in the pattern before us here at NET, we're talking about a new entrant applying to be recognized as a railroad for regulatory purposes and other purposes. So wouldn't you agree that we have significantly more authority to entertain and enter into conditions under the facts presented in the NET case?
I absolutely would. And I'm sorry, my mind was kind of ranging over a whole variety of possible exemptions that I could think of, and I just wanted to be a little inject a note of caution that
Thank you.
Not all exemptions are the same.
That concludes my questions. Any concluding?
I have
comments?
one more. I have a note here that is it correct that we have less or no power to impose conditions in an exemption petition than if the project were proposed by a full 10901 application? And counsel behind us says no, that's not true. That we don't have less. I have one more question for you, though, Mr. Bose, if you would. Do you think we should distinguish between a case where an existing railroad that starts a loading solid waste on its previously owned property, distinguish that from a case where a railroad is proposed in order to hold that material specifically for that purpose? Do you think we should make a distinction between those two?
I think the statute does. So I think the answer is yes. I mean, there's nothing before you with respect to your hypothetical of an existing railroad starting to conduct that sort of operation, if I've got you right, on its existing right-of-way, within its right-of-way, like the Susquehanna did. Mm-hmm. That doesn't require the railroad to come to you for any kind of authority or approval or to seek an exemption. So I don't think there would be any occasion for you to act.
That's also considered to be part of the regulatory gap, like some people do. So
I understand.
Thank you very much. That's all I have. Mr. Chairman?
Thank you. We will release this panel. We appreciate your patience. Thank you. You're dismissed. We will bring up our next panel, which is Massachusetts Representative James R. Macelli. And as he comes up, we will take a 5-minute, very limited break to allow our recorder a time to stretch his legs, allow us the same. And then our plan is, my plan is to, after Representative Macelli, breaks. We will have a short recess for lunch and then resume. Thank you.
Good to see you again. Ken is great. The only time I had Ken I've substituted 500 people. I'm going to get a report on this. Yeah. Ken is great. It really is. About something. Oh, yeah. Everything. It's great.
It's funny, you know, if people don't realize, he only came to the channel.
Right. Well, he's an expert in some main problems. Anywhere there's been a big problem.
We'll give him my best, yeah?
I sure will. How are you doing?
This is fun.
And I really did appreciate all the questions here. It's good to get this all out.
I actually.
Maybe it's time to sit down and figure out how to deal with it.
Thank you very much.
Thank you all for coming.
All right. Thank you very much.
No, I don't want anything. Oh, yeah.
Just fine. Yeah, this is but it was good.
Betsy didn't call you about the guy who wanted to take that. No, no. Difficulty. Probably down. Put it on a CD disc. Quality. That's why they tell people. You don't have to go But the old system, we had one of those old time cameras, just stick a VHS and you could just touch a VHS. This is
This is the guy coming up who wants it.
Yeah, I'm talking to him.
This is back home. You gotta do it.
Senator had up there. No, that's what I was trying to imply. We now
No, one slips
not,
off.
I'm not worried about it. If I went,
Something you said that must be corrected. There's something you said that it wasn't true. Yeah, that was the only thing. You said hazmat. Look at Hampton hazmat. That's right.
What's the hearing is about?
That was the only thing that was really bothering me correctly.
Please come to order.
We will now reconvene with our second panel, the Honorable Representative James R. Macelli. Welcome, sir. You've been very patient this morning. We know you need to get home and do your job for your people. We thank you for being here, and please proceed.
Thank you, Mr. Chairman, and I appreciate what you're doing this morning. I'm in my 16th term in the Massachusetts legislature and chair a committee too. So I was sitting back observing this morning. I'm not trying to inflate anyone's ego, but very professional, very well done. And we've been in contact with a lot of your staff over the period of months leading to this date. And I want to thank you for holding this hearing, because I know this isn't mandatory. So this means a lot to us. In fact, some of the folks that my office dealt with, and I'm going to get these names wrong, a woman, okay, and a gentleman named Detmer, is it? Well, I probably butchered that one too. But seriously, I'm trying to frame this, and I don't want to take up a lot of your time because I know you have a lot of other witnesses. But I think I'm going to avail myself of the 10 minutes. The gentleman, and I applaud him too, who spoke to you earlier, Mr. DeMasi, just to frame where he lives versus where we are. He lives in Wellesley, one of the most wealthy communities in the state of Massachusetts. When he talks about knockdowns, those aren't commercial buildings. Those are homes, so that they can put a $3 million home in their place. Wilmington and Tewksbury, the two towns I represent, and I'm not trying to set anyone up as an elitist, just to show you the geography is about 25 miles away. If you propose something like this in Wellesley, you'd have 20 attorneys today who are residents of the community and work for some of the more prestigious law firms in Boston. So it's easy to say, and I don't doubt his motivation. I think it's extremely honest. But it's easy to say, gee, yeah, we should do this. We should advance the rail lines, and Wilmington might not be a bad place to do this. But Wilmington and Tewksbury are blue-collar communities. I have the distinct advantage or disadvantage of having a Superfund site in each community. And the Olin Chemical site, if you were looking at a site that was least suited for this kind of operation, it would be the Olin Chemical site. There's a river of contaminants, literally a river, which has knocked out half of our drinking water supply and has forced us to go to the state begging in order to tap into the state's reservoir, so to speak, which services many other cities and towns. So we are in an emergency situation. As you read, and I don't want to be redundant, you read earlier a letter from the EPA. They're so far away from concluding or even beginning their investigation, and it's going to take years to get to the point in time where they really know what's going on. And I've sat with them, had them out to Wilmington and Tewksbury, and so we haven't even begun that. So the site itself, I know, somebody said, gee, they're not here to discuss the site, but they're here to discuss the railroad aspect of this. But the site itself isn't suited for this. And these are two communities, and I'm doing what Senator Lautenberg did earlier, talking on behalf of the district that I represent. They've had more than their share of grief in this Commonwealth of Massachusetts. And I think you'll hear from the DEP a little later on, and they'll tell you how much of an effort, or lack thereof, NET has made relative to this date that we're arriving at today. They've done nothing to date to solidify their argument with the Commonwealth. In fact, they portray themselves as babes in the woods. You know, we're trying to meet with them, but they won't listen to us. They have hired two of the best lobbying firms. If I were in Massachusetts looking for a lobbying firm, it would be Mintz-Levin, and that's who they've hired. And Mintz-Levin has a lot of their folks working for them are formally in the position of appointing some of these people in the regulatory agencies to their positions. And I'm not saying there's anything wrong with that. However, they're not babes in the woods. They've gone about it in a proper manner as far as trying to lobby this situation through. So they've been working with the Commonwealth. You know, you hit upon as New England Transrail, a rail carrier, and I don't think we've beaten that to death. I don't think we can say enough about that. And your questions have pointed and beyond what I expected this morning. You hit on areas that myself and some of our attorneys haven't even begun to touch. But are they rail carriers defined under the STB's regulatory requirements? No. They're proposing to reactivate a rail spur. You have to see this. That will service them and only them. Is this really a rail operation with public or other private railroad access? No. And New England Transrail has offered nothing to indicate otherwise. This last-minute handout this morning reminded me of a Perry Mason trial, where someone gets up and says, she did it. But we've seen nothing like this, and I even question the sincerity of that this morning. Does this contribute to the railroad infrastructure? No. This process only financially benefits New England Transrail, and I'm a great believer in the capitalist system, and undermines environmental laws. Will New England Transrail really ever connect with the MBTA line? New England Transrail has offered no evidence except that document this morning, and I, on my own, and some of my staff, have called some of the carriers in the area, some of the carriers who would have locomotives and rail cars available, and as of recently, they hadn't heard from them. This latest document, as I said, catches us all by surprise. Is New England Transrail's proposal, and I'll say it, you know, they keep alluding to it, oh, we want to do this to avoid all of the rumors that are there. Simply a smokescreen to what they actually are, which is a private freight yard operating private spurs designed to sort and bale various types of solid waste. That's what they're going to be doing. And, boy, you've got your work cut out for you, and I don't know. And I thought your points were well made about making sure that the DEP has oversight in this situation. But I'm hoping this is not approved. Principals of New England Transrail who are or were principals of American Marine Rail have had many controversial attempts in New Jersey and New York for proposed truck-to-rail and barge-to-rail solid waste facilities. This clearly is an attempt to sidestep environmental regulations, review, and public scrutiny that has been a headache to them in the past at the Fresh Kills landfill, South Bronx, and Bayonne, New Jersey. Never mind the now defunct Compost America of Englewood, New Jersey, that suffered from serious financial problems. I'm going to offer some other items in an addendum rather than go through them, and I won't bore the board with reading the specifics of the regs, and I can just leave those. We've had people here representing our governors, Governor Mitt Romney, who's currently a candidate for president, and Frank Mitchell was a director of state and federal relations in Washington, D.C., and back then, and if he were here now, would probably say the same thing, spoke very strongly in opposition to this and sent notification to my office saying they would do whatever was needed to defeat this application. The new Director of State and Federal Regs with Governor DeVal's Patrick's D.C. office, Caroline Powers, is reiterating what Governor Romney's folks said. It is well documented that New England Transrail's past filings were incomplete and had changed from the original filing. This was not incidental. New England Transrail's deliberate attempt to hide the solid waste handling component of this operation undermines their credibility. There are several jurisdictional issues, and I think you covered those, within the New England Transrail petition for exemption. Does the Surface Transportation Board have jurisdiction over the site and operations of the solid waste transfer facilities? I won't go into that. I think you did a better job on that than I could. The most recent site plan submitted in the filing by New England Transrail claims trains will enter via the north and exit via the south. If this is true, then why is there a runaround track dead-ended at the southernmost region of the site? It is my understanding a runaround track is a pair of switches arranged on parallel tracks in a yard ladder that lets the engine get by the train it just pulled in. Another thing they mentioned earlier while I was sitting out there was the number of cars that they would have per day. Another good question. They're talking about a minimum of 400 trucks a day into that site. And as I said, I wish I had done what Senator Lautenberg had done and had a picture of the site for you. It's going to be interesting getting into that small site. And 400 trucks a day, and we felt they were underestimating the number of trucks, because our understanding was they had discussions with the city of Boston relative to their solid waste. Nothing was consummated, but discussions. It would take more than 400 trucks a day to transport that waste into Wilmington. Why is the connection to the MBTA line, and that's the Mass Bay Transit Authority, not shown on the site plan? Will there ever really be a connection? There are just more examples of the vagueness, and I know they tried talking about specifics, but I didn't hear any. There are more examples of the vagueness of New England Transrail and their smoke and mirrors approach. What constitutes a rail carrier? Are they actually a rail carrier? Are they operating a railroad or a rail spur? And they were very vague about who they were going to contract with and whether it was going to be builders and who was going to ship it. All we know is their first proposal showed all of the demolition material baled and ready for shipment, and then you caught that in your preliminary meetings, and sent it back, and now they're talking about dumping solid waste on the site, lifting it up, putting it on rail cars, and transporting it out. Because most of the above questions have been identified by various comments from several parties, and you did a great job of that this morning. These issues must first be addressed and foremost by the Surface Transportation Board. These concerns, as I said, those that you discussed this morning, are not only shared by those in Wilmington and by our neighbors in Woburn, who will also be affected by these unregulated solid waste activities and operations, but not to get overly dramatic, but for our country as a whole. This case is being watched by, as you said yourself, by a wide spectrum of the political and private sector. This exemption has evolved into a precedent-setting case and could have the effect of backtracking environmental protection laws designed to safeguard public health and the environment. State, local, and federal environmental laws are also challenged. And these have been legislatively enacted to regulate the handling of waste from cradle to grave for good reason. It is clearly stated that waste cannot be removed from one segment of the population and in turn burdening another segment of the population. An unregulated solid waste transfer station would do just that, unfairly burden the segment of the population it is sited in. This has already occurred in exempted facilities in New York and New Jersey.
Representative Macelli, if I could ask you just to wrap up now.
Yes, sorry, I see the red light. I have a habit of
Give
doing
you 30
that.
seconds to wrap up. Please
Yep,
know your
I will.
full statement will be in the record. I'm sure we'll have some questions.
Thank you very much. I really want to repeat what you said this morning. I think I came here expecting a lot, but I got more than I expected. You did an outstanding job. You really did. You, as I said, you hit on questions and some of the items that we hadn't even discussed at our many meetings back in Wilmington. So I have faith in you, trust in you, and I know you have a hard job. And I hope that you will follow this through thoroughly, and once again, I know you will.
Thank you, Representative Macelli. I've got just a couple of questions for you, but I'd like to give Commissioner Mulvey a chance to start off this round.
Thank you. You mentioned the MBTA connection, and that would not occur. What is the importance of the MBTA connection that you're claiming, whether they would have it or not?
Where are you going with this? In other words, we talked to the MBTA, and I'll be honest with you, we talked to Guilford Industries. They're the people who bought out the Boston and Maine.
Mm-hmm.
And on my last conversations with them, they hadn't even been approached. So I would think you would have at least met with these folks, and I noticed nothing was produced in evidence this morning to show that they had. You would at least get something in writing saying, yes, we've spoken with these folks, and they're willing to do business with us, providing we get the approval today. But they've done nothing. So there was nothing to check. How many cars would they need? What equipment would they need? And it's all been vagueness. And that's why I mentioned the MBTA.
There's always, you mentioned in one of your addenda about NIMBYism, and that's always the accusation.
Right.
But there is this list of restricted materials in your addendum A about all the things that are restricted from going to the landfills and from being incinerated, et cetera. And this pretty much includes virtually everything that would be in the solid waste stream: lead batteries, leaves, tires, white goods, other yard waste, containers, metal, glass, plastic, recyclable papers, et cetera. Now, when it says here that there's a ban on disposal, incineration, or transfer for disposal at a solid waste disposal facility, I'm not sure.
The DEP could elaborate on that, but that's my understanding. So they haven't answered any of those questions. These are all the things that are exempted, and everything with them has been a catch-all. They don't want to approach the solid waste question. But I think the DEP could answer those specifically because that's right in their regs. But I did submit that as part of the addendum.
But where's it going to go? I mean, what happens to it? This stuff has to be, this is waste and has to be moved somehow or another. So
let me shift my argument back. The two communities that I represent, but we're talking about Wilmington now.
Mm-hmm.
Wilmington has had everything handed to it. Not only do we have the Olin site, we have the Spinizzola landfill, which is now called Maple Meadow landfill. Use the word meadow. Yeah, it does. And where they were trucking waste in from the Big Dig, and I think we all know what that was, or is, trucking waste in from the Big Dig and trying to cap the site, which I feel they've created another dump, another landfill with that. And let me tell you, I'm a very reasonable individual. I've served in office for a number of years, and I'm very realistic about the situations. I'm just saying that, when it NIMBY, maybe I should qualify that. Just Wilmington has taken more than it can handle. It's got more problems, and it's beginning to address it, but it's far from solving any of this. But, I just feel that it isn't NIMBY because there are other sites around Massachusetts that would be better suited for this.
But this suggests there's a ban on all disposal of mass. I just try to understand what these ban means when it says a ban on transferring for disposal at a solid waste facility. Would this transfer facility this transloading facility they're proposing would be a solid waste facility, would it not, under the law?
Yes,
And therefore, it prohibits transfer of any of these materials?
but if they it does. But if you give them an exemption, that's the point I was trying to make.
Right.
I think that's what they're looking for.
But if
Because
we
they
didn't-
don't want to really respond to the DEP.
And my question is, if we didn't give them the exemption, what would happen to this material?
Somebody would have to solve that problem. And that would be the DEP.
Thank you.
Vice Chairman Buttrey?
I'd just like to thank the witness for appearing today and coming all the way down here to be with us from the state. I know it's not a short trip, and appreciate you being here very much and sharing your views with us.
Thank you very much. I appreciate that. And I appreciate what you folks are doing, too. And I'm not going to stay for the complete hearing, and it's not because I'm not interested in listening to what anyone else has to say. It's because I'm running for a vacant congressional seat, or about to be vacant, by Marty Meehan. So I've got a campaign function this evening, so I'm trying to grab an earlier flight. So I thank you very much, and I thank you for listening to me, and I know you'll do the right thing. Thank you.
Thank you.
So if I could just...
Yes, no, by all means.
Just ask briefly,
Nope.
first of all, you mentioned, obviously, your constituents have a lot of concerns. Please let them know, just from one commissioner, the chairman's perspective, that we are a long way off from something happening on this property that would be rail related, that they should be concerned with. There will be a lot of procedural safeguards, even if assuming, that's a big assuming, I'm a hypothetical, that we were to assert our jurisdiction and say that we have the prime jurisdiction here, and then go forward and work with everyone on going forward. You described concerns about perhaps this applicant not being a railroad. Please know that there are safeguards in our procedures. If somebody misrepresents themselves in an application, in a filing, we have various remedies and avenues of recourse to make sure that they're not allowed to go on autopilot and just do whatever they want to do, and one day tell us that they're a railroad, the next day just decide to be a truck freight yard. Or what other concern. So just please do know that. I feel pretty strongly that there are good safeguards for that kind of concern. Let me ask you, what's your vision for this property? I'm just curious. We're all familiar with the concept of a brownfields, of trying to take a Superfund site and make it into a productive, useful part of the community again. What do you see happening on this property?
What I hope eventually on this property, once the EPA gets through with what they're doing on the site, and once all the other regulatory agencies have bowed out, that we restore it and set it up probably as an industrial park. And it would generate revenue, and it would be something. It's in a section of the town where that kind of thing would be probably more readily accepted.
So you are envisioning primarily industrial uses?
That's what I would hope.
And that's quite typical in my experience of
Right.
Superfund sites and brownfields and turning them around.
And even on a state level, we've funded a lot of the brownfields development. And I've been conversing in the Massachusetts legislature with some of the folks there about if we're replenishing the monies that maybe that we could look down the road and do something with that site.
Now, if in your vision of an industrial site at this property, if one of the future tenants under your vision were to see the benefit of having a rail line come in, maybe it could be hypothetically a Walmart wanting to have a distribution center, or be a lot of traffic, presumably, probably wouldn't be loved by every constituent, but are you open to the possibility of rail being a viable part of your vision?
If it was something, and we went through the normal process, and if it was something that went hand in hand with, as you say, a Walmart, I might not have a problem.
Okay. Recognizing even though the normal process would be minimal state and local regulation, if it were a Walmart distribution center bringing in trains full of containers and trucking them out.
And I know that isn't a trick question, because that's a big difference when you're talking about the site, putting it on a fast track to kind of develop it so that you can haul hazardous waste, or not hazardous, solid waste out of there. As I said before, this town has just been overwhelmed with all negatives. And industrial park, we would hope there wouldn't have to be a rail line probably. We would hope that we'd get, right now, biotech is the big thing in Massachusetts and is really expanding. We would hope it would be an industrial park of that nature.
If, this is my last question, I appreciate your patience. If a future tenant in what you envision as a good industrial site were to want to bring in municipal solid waste or construction demolition material, but only do it in sealed truck containers, and then place those sealed containers, never opened at the facility, onto a rail car to be brought to a facility in Ohio, for example, would you be able to support that, be neutral, or would you have strong concerns still with that?
I'd have concerns.
Okay. And I understand, I respect that.
Yep.
I'm trying to get a
Okay.
sense of where you're coming from and
Right.
what your vision is, because you do represent the people there, and it's important to us to hear that.
You know, Senator Lautenberg had that picture, and I can't get that out of my mind either, earlier. And that picture, you know, they say a picture is better than 1,000 words, and I think it spoke volumes. I can envision that kind of situation occurring on this site under the present conditions.
Now, you've had a lot of discussions, it sounds like, with EPA, as I would guess you would.
Yes, I had them into my office few months back, many months back, spoke with them recently, and they said their letter stands on its own. They feel that they just don't want to see anything happen there for a while.
So, and we appreciate you putting the letter in the record. It's Addendum D, and this is the April 6th letter from Region 1 EPA, and I'll just quote briefly from it. It says that EPA does not intend to participate in today's oral argument, but however, this letter will update the board. And then it says that EPA is still in negotiations with the potentially responsible parties for the performance of a remedial investigation and feasibility study at the Olin site. Thus, the RIFS has not commenced, and EPA's knowledge of the site has not changed materially since May 11th, 2006. You're there every day, keeping in touch with EPA. This has got to be a top-tier issue for your constituents.
We keep in touch with them about once a week.
What is this on? Are they handling this as a high-priority, fast-track matter? When do you think we'll see the RIFS started and finished, just in your...
In my estimation, not for a while.
Like months, years?
I want to say years. And I stand to be corrected, because they're not here this morning. But I think it's a long ways off.
And do you think that Region 1 has as its top priority advancing the economic development of this property, or is their top priority making sure they do their environmental work?
Making sure they do their environmental work. That's what they're looking at. And I don't like speaking for them, but that's what I would assume. And as I said earlier, the EPA has a site 5 miles down the road, and the next town I represent, they have wonderful names, Rocco's Landfill, and they just down tracing the responsible parties in that one too.
Well, thank you for your time today. Any
My pleasure.
Additional questions from colleagues? Seeing none, have a safe trip home, and
Thank you.
we wish you well, and please keep in touch if we can be of any assistance.
Appreciate it. Thank you very much, Mr. Chairman. Thank you, members.
We will now take a 45-minute, and we will be strict on that 45-minute lunch recess. Lunch locations are somewhat limited in the community, so we encourage you to grab something quickly, come back. Mr. Van Tyne, are you asking to be recognized now?
Yes, Mr. Chairman.
Yes.
Before everybody adjourns, I think it's important. I'd like to have permission to take 30 seconds to make an important amendment to one of my answers to your earlier questions, and it's not in response to anything that Mr. Macelli said.
Would you like to do that now or during your closing?
Yes, sir. I think it's important to get it in the record right now so that everybody has time to think about it.
As
before I
the
make
lawyer
a
for the applicant, we'll give you that ability to do that.
This,
Please
this,
proceed.
this was triggered by Commissioner Mulvey's question of Mr. Macelli about the waste disposal laws in Massachusetts, and I was reminded by my lawyers here that I forgot to mention in our discussion of what Massachusetts laws we would agree are applicable and which we would take the position are not applicable. there is a waste ban law in Massachusetts that requires that recyclables, specified recyclables, not leave the state of Massachusetts, that they not be shipped out of state to landfills, that they be recycled in Massachusetts. As we've indicated, we're not going to be a recycling facility, and we believe that as a matter of law, that waste ban law is an economic regulation. It is intended to encourage recycling in Massachusetts and encourage the development of a recycling industry in Massachusetts. And as a matter of law, that is one of the things that the board, the kind of thing that the board in the past has held as preempted. And since we are not going to be a recycling facility and not going to be engaged in recycling, that is one of the things that we would need to be exempted from. And I wanted to get that out now before everybody breaks for lunch.
So you would add that to your pre-certification and the other
Yes, sir.
noise and the three conditions we talked about earlier that were
Yes,
not?
sir.
Okay, so there's 4 now areas that would not be negotiable really from your client's perspective. Okay. Is that it, Mr. Antine?
Yes, sir. Thank you very much.
We'll reconvene in 45 minutes.